everyone.
Thanks, Gemma, and good afternoon, everybody. What dedication. Poor Gemma's got COVID and she's still here listening to delay in programming in NEC and JCT. So there are a couple of specific reasons why I wanted to deal with this topic. The first is that when we do our sort of annual questionnaire about what kind of topics people are interested in, people always talk about delay. Now, this webinar today comes with a bit of a caveat in that I'm not a delay expert, and generally speaking, when we're looking at delay in claims, so adjudications, court proceedings, typically, not always, but typically, you will have a delay expert. And as we know, if you've been in adjudication, it's very much a team sport. We all work together in dealing with the delay. But I'm going to look at, particularly with NEC, what you need to do in terms of your programming. And the reason I want to look at that is because quite often contractors, subcontractors still don't get it quite right, understandably, because it's quite complicated, quite convoluted, or not complicated, but there's just a lot of it there. I'm also going to look at the mechanisms and grounds for both extra time and the money relating to the extra time. But a bit of a warning that I'm not going to look at that in too much detail because there's quite a lot to cover. I just want to look at it so that you get the full picture, because again, sometimes with claims, claimants, contractors, subcontractors, forget that they need to actually show that a particular delay has occurred, and it is the risk, the responsibility within the contract of the paying the other party. And I'm going to finish off by looking at some issues that we need to look at when we're preparing delay claims and some of the legal aspects. So you recognise the term concurrent delay, and also as we're going to go along looking at clauses that you need to be wary of, and particularly how your contracts might be amended. So the aim here from your perspective is that you go away having an idea as to what you as the programmer planner in your organisation needs to be doing throughout the project, or if you're not the programmer planner, what your programmer planner should be doing, that you come away with an understanding of what we need to prove if there's going to be a claim, and also some tips when you're at that sort of mid-stage, so partway through the project, possibly experiencing some delay and want to initially prepare a claim before you get to adjudication stage. So NEC first of all. So this first section is going to be talking about what you need to do to comply with the NEC contract in terms of programming. Bear in mind this is the standard NEC, so it's not amended. The amendments, though, tend to add things that you need to do as contractor, subcontractor. It typically will not make this all easier for you at all. So just a quick run through. So the section for programming is clause 3. It's actually entitled time. And then, of course, we go, because of the strange numbering in NEC, we're then into clause 30, which deals with the time for completion and the start date. So I'm not going to touch on that at this stage. So then we're at 31.1, which is about the programme. So, we've got at least a page of type about the programme and what it needs to include. So this 31.1 states that the programme is either appended to your contract or appended and referred to in your contract data, or the contractor or subcontractor, whoever is the party doing the work in this contract, has to submit it to the project manager for acceptance within a specific timescale, which will be in the contract data. Typically, it's 28 days. Now, my preference for contractors, subcontractors, the party having to submit the programme, is to append it to the contract, and you'll see why. But once it's appended to the contract, it's agreed between the parties. You're not submitting it for acceptance to the project manager, and then the project manager says, I'm not going to accept this. And it's quite important, it's actually very important to have an accepted programme at the start of the project. Without it, you're really going to struggle in terms of particularly compensation events and delay related to them. So, next bullet point, 31.3, project manager accepts or rejects the programme within 2 weeks of it being submitted to them. Bear in mind, if the contract is going to be amended, that 2 weeks might be extended to give the PM a little bit more time. The key thing from contractor subcontractor perspective is that here that the PM might reject the programme. So of course, if you look back at 31.1, if the programme is appended to the contract, you don't need to bother with any of these provisions. There's no acceptance or rejection, which is why it's quite good to get your contract appended to the contract to avoid this. So the next bullet point, the reasons for the project manager not accepting the programme or rejecting it, are set out there in the sub-bullet points. So, for example, the third one, it doesn't realistically represent the contractor's plans. The last one, it doesn't comply with the works information or the scope. So, there's a whole raft of reasons there. And I have seen projects where, I think one of the first NEC disputes that I had that went to court, they spent the whole of the contract period arguing about the programme and whether it should be accepted or not. So they never actually agreed the first programme, which caused real issues. So moving on to this final key bullet point, main bullet point, 32.2. So the contractor, or in a subcontract, the subcontractor has to submit revised programmes throughout the project. So that is one of the key distinguishing factors of the NEC form of contract. JCT doesn't really provide for that, FIDIC doesn't, etc., etc. But hopefully you can see this is one of the reasons why it is really important to have a programme at the start that is agreed or appended to the contract, because how can you revise a programme if you're still arguing or debating about whether the PM has accepted it or hasn't accepted it, or why PM hasn't accepted it, etc. So when do you, contractor or subcontractor, have to submit a revised programme? Well, first bullet point, if the PM requests a revised programme, you must submit it. If you don't, you're in breach of contract. If the contractor chooses to, you can submit a revised programme, and also at the intervals stated in the contract data. Now, that will change from contract to contract. Typically, it will be monthly or every 28 days. But be careful. Check the contract data. Part 1, so the part that the paying party, the employer, has completed, or in the case of in the case of a subcontract, the part 1 is completed by the main contractor. So, first bullet point here, realistically, when is the contractor going to be submitting an updated or revised programme? Well, I would say at least monthly. It might be twice monthly if the contract data says so. And also, please note that a revised programme has to be submitted with any quote for a compensation event where you are saying that an extension of time, that additional time is required because of that compensation event. So please don't forget about that. That's a key area where a revised programme is required to show the additional time required. And of course, hopefully, again, you can see why it's critical that you have a base accepted programme at the start of the project, so that if you have any compensation events, you can incorporate them into that programme. So next bullet point, 32.1, states what your revised programmes have to show. So really important if you're the programmer for contractor or subcontractor, or also, if you have anything to do with the programme's delay, if you're a commercial manager, commercial director, you need to be aware that your programs need to show the following. So progress achieved on each operation and its effect upon the timing of the remaining work. So I think the first part of that would be obvious. Not sure about the second part, so the effect upon the timing of the remaining work. Next bullet point, the effects of implemented compensation events. So those are compensation events where the quote has either been accepted by the PM or the PM has made its own assessment. Bear in mind that NEC 4 slightly has changed that and includes CE's compensation events that haven't been implemented, which means quotes that you've submitted but haven't yet been accepted, or compensation events that where the PM is assessing but hasn't assessed them yet. I mean, my inclination is, how these programs are used is that if you come to make a claim, whether it's a claim that's negotiated and you reach a settlement, or a claim where you're starting and progressing via adjudication or court proceedings, the key thing is that we have documentation to evidence the position. So I think if I were a programmer, I would be inclined to include unimplemented compensation events as well. So those where you've submitted a quote, hasn't been accepted, etc. Just because that gives the true picture of what is happening, which is really what programming is about, giving the true picture. Today's programme gives the true picture of what is happening today. So what else does it need to show? This third bullet point, how the contractor plans to deal with any delays or notified defects, and also other changes which the contractor proposes to make to the accepted programme. So moving on to 31.2, this course, it's a long list of items that need to be shown on each programme submitted by the contractor. So, if you are the programmer preparing these programmes, I think you need to have this list, somewhere, easily at hand. A lot of it is quite obvious. So a lot of it is, your access date, when did you start? The contract completion date, your projected completion date, which might be different to your contract completion date. It needs to show key dates. If you have key dates under your contract, what they are, when you anticipate completing in relation to those key dates. But all sorts of other information. So just be careful about that. It also needs to include float and TRA, which is time risk allowances. Time risk allowances are sort of effectively contractor float. So again, programmers, you need to be careful to call it time risk allowances, because generally, not always, but generally float belongs to the project, and the time risk allowances belong to the contractor. So it means that if there's a delay relating to a compensation event, that delay, the float can be used to take account of that delay with the time risk allowances that belongs to the contractor. So that covers contractors' delays, contractors' shortcomings, basically. So, hopefully you can see why, it's really important to distinguish between them on the programme. And if you get them muddled and you call it float, then the employer, the paying party, will be saying, no, that's to be used to cover any compensation event delay, and not give the contractor any extra time, an extension of time. So this is probably, from my perspective, the key slide with regard to programming. Unlike JCT, NEC, as we know, is quite prescriptive, and quite a lot of the compensation events that contractors are entitled to are related to the programme. So you can see them at the bottom 4 compensation events. So if we take, for example, the first one, 60.1 in brackets 2, so the employer fails to give access to the contractor to use a part of the site by the later of the access date and the date shown in the accepted programme. So the key thing is that you've then got to look at the accepted programme to see what the date is. Another good reason to get your programme into the contract, rather than having a debate about it once you've started the work, and trying to get it agreed and accepted by the project manager. And it also means you will only get a compensation event if you can show that the programme stipulates that you are allowed access on a specific date. If it's in correspondence or some of the documentation, you're not going to be able to succeed on this claim, which is why I say it's very prescriptive. So if we just go to the top bullet point, these are the key dates that a programmer must include in the programme, or you are putting potential compensation events massively at risk, and therefore potentially losing your business a lot of money. So the dates which need to be included, first of all, as we've seen, access to part or all of the site, part of the site if it's later than the access date in the contract. Any acceptances that are required to be provided by the project manager, so acceptance for design, particular materials, etc. And this all makes sense because if it's in the programme, contractor or in a subcontractor has prepared the programme, so hopefully is going to comply with it, but also it means that the project manager knows when it has to provide acceptances for access date, etc. Third sub-bullet point, any plant and materials or other things which the employer is to provide, and also any information from others. So that could be third parties, statutory undertakers, it could be parties that are employed by the employer. Others doesn't include, so if you're a contractor, it doesn't include your subcontractors or your suppliers, they are your responsibility. So of those 4 bullet points, the 4 compensation events, so the 4 final bullet points deal with all of those. So, this is why that information needs to be included, so that if whatever isn't provided by the date in the programme, contractor, subcontractor and the subcontractor can just say, right, it hasn't been provided, it's set out the date in the programme, can I have my compensation event please for that? So other parts of NEC that refers to programming, so this is all connected with the point that I've already raised. if you are applying for a compensation event, and compensation event can include money and also time, if there's any delay in relation to that compensation event, at that point you need to provide a programme. So these provisions are all concerned with, so 62.2, if you're providing a quote for a compensation event, you include the money, but don't forget you also include the time, which means that you've got to include a programme, because we know that a programme has got to be supplied if the CE includes a request for extra time. 63.3 deals with how the delay is calculated for the compensation event, so how your extension of time is going to be calculated, and it's pretty simple. It's the extra time that the delay has caused. And 64.1, that final bullet point, it's how the project manager assesses a compensation event, including delay, if contractor or subcontractor has failed to submit a programme, and in that case the project manager just effectively provides an estimate or gauges the delay that it thinks it should be giving the contractor. So of course that's quite risky, because without a programme it's going to be quite difficult for the project manager to award any time at all. So the contractor is leaving itself open to a zero extension of time award in those circumstances. So please, if you want additional time, if you want an extension of time in relation to a compensation event, make sure you claim that with your quote and submit a programme. So this is the section I just want to deal with kind of very quickly. I don't want to focus too much on this, but it's just a reminder not to forget these points. So if you're claiming extra time, so an extension of time, that you're entitled to extra time, you need to show that under the contract a risk item, a risk event has occurred that is not your risk and that it is your client's risk. So the first three bullet points kind of set out the kind of high level areas where the risk is divided. So typically the first bullet point, actions or inactions of the contractor, so that's typically the contractor's risk. It makes sense. So if the contractor does an inaction, for example, contractor fails to provide enough personnel on the site and that causes delay, as it likely will, that's the contractor's risk. That makes absolute sense. Typically, if the contractor does something that causes the delay, so an accident on site, which is caused by the negligence of the contractor or other people engaged by the contractor, that will typically cause some delay, and that's the contractor's responsibility. There are also, so let's look at the third bullet point, delays caused by the employer or the employer's agent. So, project manager is supposed to give consent to something, by today. They failed to give that consent, therefore contractor can't start work. That causes a delay, and typically that will be the employer's risk because they had control of that. Be careful though, because as contracts get trickier and trickier in construction, what you typically see is some risks where it is under the employer's control, but the risk is specifically stated as belonging to the contractor. That's not in your standard JCT or NEC, but we see rafts and rafts of amendments to these contracts nowadays. So just be careful that you're not picking up risks that really should be the employer's risk. And then the second bullet point is sort of the mid-ground. So these are events that neither, that they're no one's fault really. the sort of neutral events, so things like arguably ground conditions, weather. You know, we experience weather in this country, and sometimes it will impact on a project, but who takes that risk? You can have a debate either way as to who's responsible. Third parties, so genuine third parties, not the contractors, subcontractors, because they are the responsibility of the contractor, and not a project manager under NEC, because they usually are the responsibility of the employer. But for example, statutory undertakers, the water board, the electricity, the local authority, the planning authority, you know, they all kind of sit in this mid-ground where really nobody has much, well, neither employer nor contractor, you know, has any real authority to get them moving if they're causing a delay. So who takes the risk of all these people? Well, you need to look to your contract and what that says about the risk. Now we're going to look at a summary of that in a minute, but what provisions, and as a high level look, what provisions do we have to deal with this? So typically we have an extension of time, so that extends contractor or subcontractors in a subcontract completion date to avoid it having to pay liquidated damages for delay. We also have second bullet point, loss and expense, so that is contractors' way of recovering its costs on site if it gets an extension of time. So if there's a delay, which is effectively the employer's risk. So I'm not going to cover time at large just yet. So contracts, what do they say? Well, typically they have both grounds to determine when the contractor gets an extension of time. So who's taking the risk for these items that contractor can prevent, employer can prevent, and that mid-ground. And then we have mechanisms that both parties have to follow to make sure we have these procedures to go through and to comply with, to get the extra time and the extra money. Just note, beware of conditions precedent. I probably refer to these every webinar that we have. They're tricky little clauses, mainly impact on you guys making these claims, because they effectively say that unless you make these claims within certain timescales, your right to extra time and extra money is zero. So, you know, really, really tricky. So make sure you know what notices you need to issue and that you issue them on time. So just a quick look at these notices. It's tedious. I mean, I find it tedious, and you know, it's my life, I suppose, as a lawyer to an extent. But JCT, let's run through this really quickly. The grounds for an extension of time are dealt with. So this is the design and build, but the other contracts are very similar. Clause 2.26. So they're called relevant events. You'll probably be familiar with them. For loss and expense, so that should say grounds for loss and expense at that second bullet point. They're at 4.21 of the contract, and they're called relevant matters. So bear in mind, unlike NEC, JCT separates the time and the money in terms of where they are in the contract. 2.26 for the time, 4.21 for the money. Similarly, the mechanisms, the notices, extension of time 2.24, 2.25, 28 and 29. For the loss and expense for the money at 4.9 and 4.20. In NEC 3, the grounds for the extension of time and for the money are all dealt with in compensation events. So it sort of makes it easy providing, as I said earlier, you remember to claim when you make a quote, not only the money but also the time. And the mechanisms are at clause 61 to 65. So let's skip on to this chart and I'll explain this. So these are the grounds for getting extra time and extra money. The green is JCT, pink is NEC. So the reason that green is split is that, as we've seen, we have clause 2.26 was extension of time under NEC, so that's why the top one at the left hand side says EOT, so that's extension of time under JCT. The one underneath is loss and expense, L&E, and if you remember that was clause 4.20 odd. So that's why it's split, because under JCT we sort of have a hybrid. In some instances you get an extension of time but you don't get loss and expense, whereas with pink, which says CE, compensation event, so that's NEC, it's all done under the compensation event mechanism. Just be careful with your Z clauses, your amendments to NEC, because what I'm seeing quite a lot of is amendments that effectively split the compensation events in the same way as they're split for JCT. So let's see how they're split for JCT. Well, the first one, so if we've got extension of time at the top left, the next one says VO, so that's a variation. So if you have a variation under JCT, you get an extension of time if it creates delay for that variation. So that's fine. Do you get a loss and expense? So your extra money as well for that related to the time, not related to the cost of variation order. So do you get extra money, your loss and expense relating to the extra time on the site? Well, yes, because that second column underneath says VO. So yes, you get the cost of your time. But if you move along to the one that says weather in green, yes, you do get an extension of time for bad weather. It's got to be exceptionally severe weather. So it is, that's not just any bad weather. It is, it's really difficult to get extra time. But if it is exceptionally severe weather, so storm and wind, you probably will get an extension of time. Do you get your loss and expense? So your money relating to the extra time on the site? No, because it says not applicable underneath it. The next one is relating to ground conditions. You don't get anything under JCT. You don't get either extension of time or loss and expense, entirely the contractor's responsibility. Next one along, SU, statutory undertakers, another common claim. So they include local authority, water authority, electricity board, all these kind of third parties that are probably really common in your work. So yes, under JCT you get an extension of time if they cause you delay, but it says not applicable in the next column, which means you don't get your loss and expense. You don't get the cost of that extra time on site. And this is what I mean by the sort of hybrid way in which JCT deals with it. It's sort of a compromise. You get the extra time, so you don't have to pay relief from paying liquidated damages, but contractor, you have to bear your own costs on the site. So it's a bit of a sort of halfway house. Provisional sums are dealt with in JCT, but actually there's nothing in there for in NEC for them. And if a provisional sum occurs, you get both an extension of time and your loss and expense. Ditto if there's an impediment by the employer or others engaged by the employer, and you get your loss and expense. So that makes sense for both provisional sum and impediment. because they are items that are wholly within the control of the employer. FM is force majeure, so we should all know what that is now. 20 months ago it probably included COVID. It definitely doesn't now. But if there's a force majeure event, we've got this hybrid situation in JCT. You get an extension of time, but you don't get your loss and expense. If you look at the pink, so that were compensation events. Is it a compensation event if there's a change to the works information? So that's effectively a variation under JCT. Yes. So under NEC, you get your time and you get your money relating to that time, unless the contract has been specifically amended. It wouldn't typically be on this, but weather is an example of where the amendments might include this hybrid situation to give you time but not money. And as I say, this is something I am seeing a lot nowadays. The next one along, change to the site information. So this is ground conditions under NEC. It is a compensation event. It's quite limited because it only relates to ground conditions effectively you wouldn't have anticipated, taking account of the fact that usually there's a load of site information in the site information appended to the contract. Again, this is another one where the amendments on your particular contract might change that situation to give you that hybrid. Ditto statutory undertakers, the next one along. As I've said, provisional sum, there's nothing in NEC about provisional sums, so typically it would be a change to your works information. Penultimate one, impediment by the employer. We've already seen that. If the employer stops you from doing something, then typically that will be a compensation event. And force majeure, usually, again, that is a compensation event. But again, that is one, particularly post-COVID, where employers are taking the opportunity to amend it and put in the hybrid situation that we get in JCT. So hopefully that's useful. The mechanisms, so this is JCT. I want to skip this, but why I've included it in these slides is to give you a full picture. So this gives you the summary of the notices that the employer has to give in order to deduct liquidated damages. So there are 4 notices there. So, make sure they have given those notices, because without them, they can't deduct liquidated damages. This slide, again, I want to skip through it, but again, I've put it in for completeness. It effectively goes through, you can see there are 6 bullet points. So the first one typically, so all the odd number bullet points relate to a clause, and the next bullet point explains what that clause says. Now this is important to you contractors and subcontractors, because this is what your notices need to say when you're claiming for delay. So it's for the time limit, you've got to give the notice within X days. You'll see for the first one it's forthwith, so immediately the delay becomes apparent. So think of this high level. As soon as you know you've got a delay, you need to be thinking about notifying. Forget about which contract you're on for 2 seconds. Just think, right, we need to be thinking about notifying. And then start to look at the notice provisions, because you can pretty much guarantee in all construction contracts you are going to need to notify. If you notify and you don't need to, no one's going to penalise you, but you will definitely be penalised if you don't notify, and that means if you don't notify within the timescales, or if you don't provide the right information. So, the odd bullet points are the clause and the timescale. The even one is talking, so number 2 is talking about what information you need to provide. So that's just there for completeness, but hopefully, that might be useful when you are submitting your notices, because the clauses are pretty tortuous, to be frank. This slide is the same, but it's for loss and expense. So remember, you're going to have to double up on your notices, because with JCT, you've got your delay, you've got your extension of time notice, and you've also got your money, your loss and expense notice. Similar basis, clauses and timescales, and then next bullet point, what you need to include in those notices. Under NEC, it's prescriptive, but your one key deadline is that you've got to notify your compensation event, and all that means, so that's 61.1/61.3. Remember, you've got 8 weeks in a contract. In the subcontract, I always forget this. I can never remember whether it's 6 or 7 weeks to notify. But in each case, beware, because typically that will be amended somewhere in your contract, usually in your Z clauses. It's quite often halved. So, again, if in doubt, notify a compensation event. Don't mess about. Don't risk being out of time, because, as I said earlier, these are conditions precedent. If you don't notify properly, so within the timescale and with the right information, then there is a real risk that you won't get your extra time or your extra money. It might seem unfair, but that is the position, I'm afraid. So this is a summary of the timescales with NEC. Hopefully you should be familiar with this, because we talk about them probably every other webinar that I do. Just note this final bullet point, the case of Northern Ireland and healthy buildings. If you're an employer, you probably want to use and refer to this case. If you're a contractor or a subby, probably not, because effectively what it said was that at the end of the day, if you're going to dispute resolution, it doesn't matter what you said in your quote. What the court is interested in, what an adjudicator is interested in, is what your actual costs are. So just be aware of that, and it's why the evidence, the documentary evidence, is so important. And you can't just rely on we've given a quote. So that's our substantiation for this claim. Okay. So, making a delay claim. What you need to bear in mind, so this is the sort of techie bit where it's sort of lawyer meets delay expert meets contractor or subcontractors, programmer meets the site team. It is, all of this is very much a team effort between all of us. The lawyer doing the legal bits, which I'm going to be talking about, the expert programmer doing the programmer bits with the help of the contractors programmer who knows the background behind all the historic programs, which are all brilliant evidence, and can very often sort of explain the bits that fall between the lines. So well, we didn't put this on the program because it wasn't important for these reasons, or this wasn't on the critical path. This the contractors programmer has lived and breathed this, and understands the logic behind it, and the site team all critical because they understand what happened on site and the realities of the situation. It's all very well doing a program, but if you couldn't get access to something for another reason, or so that's where the site team come in, because they can say, well, this is what was actually happening on site. I sent an email, saying, well, why can't we get access? The programme says we need access. So as I say, it's a team game. So what do we need to show to get that extension of time? This applies irrespective of the contract that we're working on. And I think sometimes people get confused about this. They think that because statutory undertaker caused delay, or there was a variation which caused delay, that here's the miracle cure, this gives us our 3 weeks extension of time. No, that's not quite correct. There are several other steps to go through first. So we need to show that the variation work caused critical delay, so it genuinely impacted on the completion date and extended it. We need to look at whose risk is it, so refer to the contract. We've seen, from that chart, variations, they are the responsibility of the employer. So, that does entitle the contractor to an extension of time. What about weather? Well, it depends on, how severe the weather was and what the contract says precisely about whether that gets contractor an extension of time or not. So don't forget about that stage. Next stage, compliance with those contract notices. Don't forget that, because that can be, immediately a debarring. It debars you from your extra time and your money if you haven't served the notice within the correct timescale and giving the required information as per the contract. Assess the compensation payable is the next one. Again, we're looking at causation here, so it can't just be, the contract price was 3 million, it's cost us 3.5, we expected to make $500,000 profit, so we've been paid 3 million, so the claim's 4, to take account of the extra $500,000 profit and the $500,000 overrun. It's not that simple. We need to show, what delay was caused by that variation, as opposed perhaps to contractor caused delay because it didn't have sufficient personnel on site, and we then need to show the cost of that extra time on site, and obviously it can't include the delay caused by, for example, contractor not having sufficient personnel on site. And of course, as with all contractor claims, contractor and subcontractor, has got to consider mitigation. This isn't an open check. We've got to consider how to reduce those delays and reduce the extra time and the extra money. So that's what we've got to prove. So that's delay. I want to look at disruption very briefly, because we are very much getting into the realms of evidence here, and every case is different. So there's a definition in the SCL, that's the Society for Construction Law. I think it's actually called the Delay and Disruption Protocol. So if you're a programmer, I would recommend that you read this at some point, because I think it might be helpful. It's not a substitute for complying with the contract, and particularly, we've seen with NEC the very prescriptive requirements, but it's helpful in that it sets out, how you progress things if you are going to make a claim to an adjudicator or to a court. So if you know that, you can, incorporate that if you get to the stage where employer/project manager, contract administrator is saying, no, we're not going to give you this extra time. We don't think it's justified. You can look at this and think about the things that you are going to have to prove. Now, this is disruption, which is distinct. It's very different from delay. It's defined in the SCL protocol as disturbance, hindrance, or interruption to the contractor's normal working methods. Now, the 2, 4, 6 bullet point down is one of the key ones, because it says usually it doesn't cause critical delay, and that's often the way we distinguish it. If you've got critical delay, something that has caused delay to the completion date, it is delay. Usually anything else is disruption. This second bullet point is very, very true though. It's usually obvious when you're on the site, but it's quite difficult to prove. It can get messy, and it's usually about, you know, having to bring extra people onto site, not being able to work in the way that, you know, you had agreed in the contract to work, etc. It says it's difficult to prove, and usually what we need is a lot of documentation to prove it. Dated photographs are often very helpful, but quite often you need resource details as well. And that kind of follows on the next bullet point. Claims are usually for additional costs over and above the planned resource. So there's a bullet somewhere where it talks about what you have to prove, what you planned. Yeah, third from the bottom. What was your planned resource, and was it adequate? So, you know, all that information is, you know, is really good if you've got it in detail, because if it wasn't adequate, then a calculation has to be done to say, well, you know, the resource was, you know, 20 people on the site, it wasn't adequate, 23 would have been adequate, and we had to have 27, so the claim is the difference between the 23 and the 27. Need to show who caused the disruption. I mean, that, you know, that is just absolutely standard, because if you, contractor, have caused your own disruption, you're not going to be entitled to make a claim. And whose risk is it? Ditto. If it was the variation that caused the disruption, you're probably going to be okay. If it was weather, it depends on the kind of weather. You know, if it was you causing it, yeah, as I say, you know, you've probably got real problems. Second, penultimate bullet point, how did the work proceed? It's always really useful, that, because you're looking at how you were disrupted. So how you were going to do the work, how you planned to do the work, how you had to do the work in the end, and why, what was the reason for it, and, you know, to show why that disrupted you. Now, sometimes it stands to reason, but not always. And as I've said at the bottom, quite dull, but it's your records that are key. You know, the stuff that's in writing, you know, your diary entries, your report, your monthly, weekly reports to your employer, emails, all that kind of useful stuff. Global claims, I'm just going to skim through this, because we all like to, particularly employers, like to talk about global claims, but I think we get a little bit muddled as to what a global claim is. I mean, essentially, a global claim is a contractor in a contract who says, I should have completed, the completion date was the 20th of February, I didn't complete until 2 months later, and I'm not responsible for any of that delay, and therefore I want an extension of time for the full period, rather than going through and saying, well, you know, of that 2 months, 3 weeks related to variation 27, a week to variation 4, 2 weeks to storm Anwen, 2 weeks to ground conditions I couldn't reasonably have anticipated, which aren't my risk. Now, quite often, it is possible to separate it out, and it is best if you can separate it out like that. Sometimes it's not possible. A global claim is possible, so on that basis of 2 months, separate, you know, I'm not separating it out, but you need to be careful, because you need to sort of do a reverse calculation and show, you know, for example, you know, it's 2 months, and I know it's all down to the employer because I, contractor, haven't caused any delay, that, my initial program was reasonable, that if we hadn't suffered from these events, we would have completed on time. So you're kind of looking at it from the reverse and justifying it. It's not sufficient just to say, I want the full 2 months because of these items. But, it is possible to bring a global claim. The courts will support them. It's just a different way of proving a claim. So let's skip on. Walter Lilly case. It's Walter Lilly and Mackey. Quite an interesting case to read, just to see if Mackey was it was an individual and having quite a nice house renovated in London. So it's quite interesting to see how they operated. But this is your key case law in terms of those notices that I've been saying are so important, and they are important. But this case gives you a little bit of leeway if you haven't quite sent formal notices out. But, and this is a big but you have effectively informed the PM, the contract administrator, or whoever. So typically that might be an informal notification. So you've told them in some minutes, in a meeting, and it's been recorded in the minutes, or you've told them in your weekly progress report, or it's been discussed, or the employer has told you, for example, I've got one at the moment, don't work on this bit of the site, don't worry about delay, we will sort that out at the end of the project, so they're acknowledging they know, so they've given themselves notice, they know that the contract is going to be delayed. Now, bear in mind, it is far easier if you've submitted proper notices, because you're not then having to argue this case and find that information to show that effectively the employer did know what was going on, they did know that there was delay and that there was going to be a claim. It's just that the proper formal written notice hasn't been sent. But, this is, if you need to argue this in meetings, that's the case that you need to be talking about. Concurrent delay, I'm just going to skip through this. Concurrent delay is basically where you have two delays at the same time. One is something that the employer is responsible for, so a variation, really severe weather, storm Anwer, what else? Delay by statutory undertakers. But at the same time, there is also a delay caused by the contractor not having had sufficient personnel on the site. Now, effectively, it sort of goes with the contract. So, if you're entitled to an extension of time for the main cause, then you get your extension of time. So, contractors are probably okay, but for just to but for where's it going? Yes, this case, which 2014 case, North Midland and Sidon, and in this case, they had a clause that specifically said and it's quoted there, any delay caused by a relevant event, so we're under JCT, so we know a relevant event gets you contractor or subcontractor and subcontractor an extension of time. But what it's saying here, be careful, if an event that's a relevant event is concurrent with another delay for which the contractor is responsible, So, for example, contractors not got enough personnel on site. Then that delay, and it goes on to say, shall not be taken into account when assessing a claim for an extension of time. These clauses are really, really popular at the moment, and you can see why. Because it means that if you're causing delay for a 2-week period and there's an event where you would have got an extension of time, this clause means you don't get your extension of time and you don't get your loss and expense or your additional money to cover that time. So just be really, really careful with that. As I say, they're really, really popular clauses at the moment. So we've gone over slightly. So I think just, again, this is about the documents. How can you minimise the effects of delay? You know, obviously there are practical things you can do on site, but records, from my perspective, and from whoever negotiates, you know, the final account at the end of the day for you, you know, these are key for us. Accurate records, share the records. So, you know, if there are delays, you know, that you're going to be claiming, don't be shy, show them to the employer. Photographs are brilliant, they need to be dated, obviously. Programmes, this is why programmes are so important, because they show what was going on, you know, on a particular day, providing they've been kept up to date. Minutes of meeting, all these documents are really, really important for us if we have a dispute over delay. I've mentioned the Society for Construction Law Protocol, which sort of brings us to a bit of a hurried end. Happy to answer any questions if there are